The Honorable Justices of the Supreme Court of the State of Iowa. Hear ye, hear ye. The Honorable Supreme Court of the State of Iowa is now in session.
Thank you. Please be seated. And welcome as well. And let me particularly welcome, first of all, the students from Bergman Academy. Welcome. The criminal justice class from the University of Dubuque. And then finally, the law students from China that are part of a program through Drake Law School. There you are in the back. So, ni hao. All right, we have 7 cases that are scheduled this afternoon. The first 2 are oral arguments that we'll hear this afternoon, and the other 5 will be submitted to the court without argument. The 2 oral arguments are Larry Hedlund versus State of Iowa, and the second case is George Struve versus Perry and Clayton Struve. The 5 non-orals are Iowa Supreme Court Attorney Disciplinary Board versus Donald Capitosto. And then the final 4 cases are State versus Mosley, State versus Curry, State versus Crawford, and State versus Perry. Again, those last 5 cases are now submitted to the court without argument, and we'll hear the arguments in Hedlund versus State of Iowa and others. Mr. Duff.
Please the court, counsel. My name's Tom Duff. I represent Larry Hedlund in this matter. This case comes before the court after the granting of a summary judgment dismissing the case in toto. The 3 claims that we've appealed are the 70A.28 claim, the age discrimination claim under the Iowa Civil Rights Act, and the claim for tortious infliction of emotional distress. If I could address the 70A claim first. The district court at the time it issued its ruling on the summary judgment on the 70A claim did not have the benefit of this court's decision in Walsh. We think if the court had that decision, it would have been a different outcome, because we do think that Walsh and the Worthington decision, which preceded it and was favorably cited in Walsh, is dispositive of this issue. There's really no discernible difference between Hedlund and Mr. Walsh. Both are merit employees. The court even recognized that in the Walsh decision, referring to Ms. Worthington, who worked for DPS and was, in fact, an 80.15 employee as merit-based. Granted, they're not the folks that work for DPS are not under 8A, they're under 80.15, but they all have a right to a pre-termination hearing. They are not considered at will. So we think there's no discernible difference between those 2 cases, between Walsh, Worthington, and Hedlund. The court did look at, in Walsh, whether there was an express or implied exhaustion requirement in 8A. If the court were to do the same thing with respect to 80.15, there is no express exhaustion requirement in 80.15, just like Chapter 8A. In addition, one cannot imply an exhaustion requirement for the same reason that the court found you couldn't imply one in Walsh, which was the unequivocal declaration that a whistleblower can bring a civil action. If the court in Walsh looked at the legislative history of 8A, and if the court were to do the same under 80.15, again, we think there's substantial evidence that the legislature did not intend for this to be the sole remedy for a state employee who is claiming whistleblowing.
What additional remedies would be available under the whistleblower claim that would not be available to your client in the 80.15 context?
Well, I believe in the 80-15 context, he would be entitled to reinstatement with back pay. I don't think there's any ability to obtain attorney's fees or costs under the administrative process. I also don't think there's any avenue for an injunctive relief, which also exists under under 78.28. So to follow up on your question, I think one of the issues that we raised in our brief, which I think is an issue of first impression in this court, is what are the damages or what is the relief that is available under 78.28? There's one unpublished Court of Appeals decision. It's the Zanziger, I may be mispronouncing it, where the court addressed that issue and concluded that only equitable relief was available. However, the court in that case did say that this court could easily conclude that a jury was available under 70A if the plaintiff was seeking monetary damages only, which is in fact what Hedlund is doing. Hedlund in his petition did not seek reinstatement. He only sought monetary damages. If you look at the language in subsection 5A, it talks about the employee being entitled to affirmative relief, including reinstatement, comma, with or without back pay, comma, or any other equitable relief, including attorney's fees and costs. And granted, reinstatement and attorney's fees, injunctive relief are all equitable, but back pay is a legal remedy.
I thought back pay is considered part, in an employment case, is considered part of equitable relief. For example, I remember in the Lee case, I'm sure you know about that case, we awarded back pay even though under Ex parte Young, even though only Ex parte Young only allows equitable relief.
Well, I would think, I guess I'm not as familiar as I probably should be with that case, Your Honor, but I think there's additional language in 78.28 that would allow.
Maybe you're right. Maybe it's back pay from the date of the order reinstating her, not back pay all the way back.
Right.
Yeah, that may be the distinction. I take that correction.
Yeah, and I believe, Your Honor, that the term the statute uses is affirmative relief, including reinstatement, etc. Affirmative relief is not defined in 70A. In fact, it's not defined anywhere in the code that we were able to find. But the definition from cases would indicate it is a counterclaim for money damages by a defendant is sometimes called affirmative relief. But I think in the larger context, if you read the statute as a whole, which the rules of construction require you to do, under subsection 6, the statute's unique because it does allow for a direct cause of action, a civil cause of action, and it also gives the employee the option of filing or pursuing an administrative remedy through, I think it's the Employment Appeal Board for 8015. But under the section that gives the employee the right to file the administrative action, it says if a violation is found, the employee may be reinstated without loss of pay or benefits, or the PERB, the administrative agency, may provide other appropriate remedies, which strikes me as a broader term than affirmative relief. To construe the statute, I think the only way you can read that is that surely the legislature did not intend to give the administrative agency broader relief powers than it would give to the district court. So for those reasons, we think Mr. Hedlund on remand is entitled to money damages, and with that, the right to a trial by jury.
How about the intentional infliction claim? And I want to draw your attention to the Smith case, of course, which is an interesting case.
Right.
Briefly in Smith, as you know, we did affirm an award of intentional infliction of emotional distress damages in an employment case. But one could argue that the Smith case is distinguished from your case for a couple of reasons. One, the acts in Smith occurred over a significantly longer period of time. I think that's objectively just true. I mean, it was a period of several years in Smith.
Correct.
And secondly, in Smith, not only were there statements about the mental stability of the plaintiff, but there's also a lot of personnel action going on, withholding of a promotion, changing job responsibilities, et cetera, et cetera. And, but bottom line, tell us how your case is at least as strong as Smith when you don't have some of the attributes, which includes length of time and kind of intense. If I added up the number of acts in Smith, it would come out to, I don't know, 20, 30 maybe, I don't know. But you seem to have a tighter time frame with less going on.
Right, and I think one of the factors was the length of the conduct. It wasn't the only factor. And I think, to answer your question, there are several factors, I think, that makes this case as bad or worse, if we want to put it that way, as Smith, and certainly worse than Vinson, which the district court relied on. And the reason being, one of the factors that the court looks at is who is engaging in the conduct. Is if it's supervisor, that's important, and that's what we have here. I think what makes the case stronger is the actors that are involved. Smith involved somebody that worked at the engineering department at Iowa State University. Mr. Vinson was a bus driver. Hedlund worked for the Department of Public Safety. His boss was the director. The people who engaged in this conduct were the director of the DCI and the assistant director of the DCI. They're the elite top law enforcement of the state. So who the actors are, I think, is important. And the conduct, although there weren't as many acts, we think the record certainly would support that the conduct that those supervisors engaged in, Paulson, who was the director of the DCI, and Myers, who was the assistant director, some of the acts that they engaged in were criminal in nature. For example, in the course of the investigation, we believe the evidence would support that Director Paulson made false statements to the PSB, which is the Internal Affairs Unit. That's a crime. It's a fireable offense and a crime. She also submitted a false report to the DCI or to the PSB, also a crime. Paulson and Myers also engaged in retaliation for whistleblowing, which under 78.28, I forget the subsection, is a crime. So we have criminal activity by some of the state's most top law enforcement officials, and that makes it outrageous.
That's what I want to get to. Tell me something, and what's your elevator speech? Outrageous has got to just be out there. And the things you've said, even if I were to say that all of those things that the record supports, give me more. Outrageous is a tough standard. So it should scream at us, this outrageous conduct. Can you summarize in an elevator speech what is the outrageous conduct?
Yes, Your Honor. Well, in addition to what I've just indicated, Director Paulson and Myers provided this false information to then Governor Branstad, knowing that he was going to have a press conference where he would say that Hedlund had to be fired because of the safety and morale of the department. And it's one thing.
How'd they know that? I mean, I understand they briefed the governor, but are you suggesting that they scripted this out about safety and so forth?
Well, they certainly made statements to the governor that Hedlund was a threat to himself and others.
Well, sure, that could be, but in the governor's office, no doubt. But did they have reason to expect that the governor was going to make a statement to that effect?
Well, I believe the meeting. There was a meeting shortly before the press conference. So the day of the press conference, there was a meeting that Paulson attended, where those statements were made. So she had to have known he's having a press conference. So we think that that's certainly a lot different. When you it's one thing to accuse someone that works at Iowa State of mental illness. It's something completely different to make a claim that a law enforcement officer is mentally ill. That is a career ender because you never really recover from that.
I'm still waiting for more outrageous. That kind of conduct, like I said, I don't condone that, but those kind of comments, I was a former prosecutor. Cops got called a lot of dirty, nasty things. There are many things that are not fair and are possibly damaging to a career. I'm waiting to hear some outrageous, the criteria, so extreme, beyond all possible bounds of decency, atrocious and utterly intolerable in civilized society. That's what I'm waiting to hear.
Well, Your Honor, and I think it's one thing for citizens to say something that's defamatory about a police officer. It's different. I think it's a whole different ballgame when it's the supervisor making a comment about their subordinate employee. I think the other thing I would point out, Your Honor, is that we think one of the most outrageous acts that they engaged in was they set up this whole straw man that he was mentally ill, which was no way true, and then they went to his home to take him out of service, there is evidence in the record that is not the way officers are taken out of service. You don't go to their home at 6 o'clock at night with 3 agents with guns and bulletproof vests on to take him out of service.
I mean, assuming your position is that he did not suffer from a mental illness, and that you're very consistent on that. I mean, why is the only people that were present there were going to be? It wasn't like it was done in front of the public or a bunch of third parties. The only people that were there for that incident were the people that were taking his gun and his badge and him. Why would that be such an outrageous incident? That would likely spark this severe emotional distress.
Well, one, because it's never been done before, and I think the other reason, Your Honor, is that there is evidence in the record that the only reason that they did it that way was because they were hoping to provoke a reaction from Hedlund that would give them further ammunition to support their decision to terminate him. I see I'm running out of time.
You may sum up.
All right. Well, Your Honor, I'd like to come back on rebuttal and talk a little bit about the McDonnell-Douglas issue, which may take up my whole 5 minutes, so thank you.
Mr. Duff, thank you as well. Mr. Peterzalek.
Thank you. May it please the court, Mr. Duff. I think I'll start where some of these questions left off and talk about the intentional infliction of emotional distress claim. It is a significantly different situation than what was in the Smith case, which this court, even under those egregious circumstances, noted was a close call. In this case, there wasn't a situation where there was a years-long, I think the term that the Supreme Court used was multi-year psychological warfare, harassment. More significantly, the people involved lied to Mr. Smith about getting raises. They lied to Mr. Smith about being put in for promotions. They did all of these things over a period of time. And the other significant issue that I want to note, too, there are 2 components that are often critical in analyzing these emotional distress claims. One is the outrageousness of the conduct, and the other thing is the severe emotional distress. And in Smith, they also noted that this was different than the usual case because there were emails back and forth that even pointed out that Mr. Smith was on his edge. I think we almost got him there, all kinds of evidence like that. So in this case, we don't have the evidence of outrageous conduct. Mr. Hedlund was put on administrative leave and eventually, after an investigation, received a notice of termination for conduct that he himself acknowledged he was involved in. There isn't anything particularly outrageous about that. The other significant component I want to touch on is the severe emotional distress. If you look through the briefing that the plaintiff provided, there are 2 sentences in their opening brief about that. They say Mr. Hedlund was depressed and he had difficulty interacting with his family for some period of time. That's it. Nothing else in there, no response whatsoever to our arguments about the lack of severe emotional distress that we put forward in their reply brief. There just isn't any evidence in the record of severe emotional distress either, which is a component for denying these claims. And in fact, if you look at the emotional distress claims, intentional infliction claims that this court has decided over the years, many of them have in fact been decided on that element as opposed to the outrageousness element. It's a very different situation.
What does the record reflect with respect to, and this relates to some extent the outrageousness of the conduct, to whom was the report made that supports the claim for the whistleblower violation, and what exactly was reported?
To whom the report was made regarding his whistleblower claim? The whistleblower claim arises from a complaint against himself that was filed with the Department of Public Safety.
And that's the only claim. The factual basis for the claim, as I understand it, is his report of his failure to enforce the traffic law at that particular point in time. Is that right?
Yeah, his claim is premised on somehow being retaliated against for the incident involving the vehicle that the governor was riding in.
You call it was a complaint against himself, but he was also blowing the whistle on a whole situation, right, including others, correct?
Well, if you actually read his complaint, to quote him, I accept full responsibility for not doing my job, is what he's complaining about, and that he should have done that. Yes, there is an incident involved. I agree with you, Justice Mansfield, that he's laid out in great detail in that complaint against himself.
And to whom was that made?
Pardon me?
And to whom was that made?
That was made to is either the commissioner or the director of the DCI. I'm not sure which. I think it was sent to the director of the DCI and with a request that it be forwarded to the commissioner for the Department of Public Safety. And the issue or the relevance of the complaint against himself, that's one of the issues that we raised, that if you complain about yourself or doing something wrong, that doesn't protect you from give you a safe pass to do those things and not have any repercussions. And that's the argument for that. And again, I want to circle back a little bit to the outrageousness issue, if I might. Much more in line with the Vinson case, which in that case there was even a campaign to harass the person. The person was told, potential employers were told that she was dishonest and had falsified records, things of that nature. None of those happened here. How about the business of the trip to the home? I mean, you're familiar with it, of course. So it strikes me as a little odd that they have officers with vests and so forth and going out to the home. So let me just invite you. What do you make of that? Well, he was on leave at the time. And that's really kind of the paradox of this situation, is that Mr. Hedlund goes on and on about how there was no reason whatsoever to believe that there were any mental health issues, and then asserts, well, you came to my house and everything could have gone south, and oh my God, this could have been bad. And if you look at it that way, the better answer then is to have him bring his guns into the workplace. It doesn't really, their arguments don't fit together. But more significantly, as you pointed, I think it was you, Justice Apple, pointed out that when they arrived at the house, it was just the people from the Department of Public Safety and Mr. Hedlund. His family wasn't there. There weren't neighbors there. It was a one-on-one situation. And more importantly, or just as importantly, there isn't any policy that says you can't do that. Mr. Duff alluded to that. But like many of the things he told you, there's no support in the record for those things, and he doesn't cite to support in the record for those things in the briefing. There isn't a policy there, and they didn't put a policy in that says you don't do that. There aren't any criminal acts being perpetrated by the director of the DCI. They assert those things, but don't cite to parts of the record for that. So these hyperbole aside, there just really isn't anything particularly outrageous about putting someone on administrative leave with pay, pending an investigation, which ultimately then resulted in a notice of termination, which started the 8015 process, which I think I'll move into at this point with the whistleblower case. And I think it's very important. Mr. Walsh and Mr. Hedlund were very differently situated. The situation with the analysis in Walsh is very different than the situation under 8015, and I want to
explain to you people why that is. I can see Justice Apple probably about ready to ask that question. In Walsh, there was that interplay that the court had to deal with between Chapter 8A and Chapter 70A.28, where you had two almost identical statutes, and then also with both of them going to PERB and different things like that. But in this particular case with Walsh, one of the things that was important in the analysis in the Walsh case was legislative history and legislative intent. And that fully supports our position in this case. Here in 8015, in the 1970s, when the Iowa Administrative Procedure Act was adopted, the legislature expressly put in an administrative process, a contested case process that had to be followed if they had to be instituted by the department, and then if the person wanted to contest that discipline, they could do so. Under 8015, they have to be paid throughout the pendency of that proceeding. They obtain full benefits during the pendency of that proceeding. Nothing can be done to them until after a hearing in front of the Employment Appeal Board. One difference between Walsh in this case, and the court made a significant finding that the process for the administrative process under 70A.28 came about after there was a civil remedy that was adopted under that same statute. It was in 1989. Here, 1974, the legislature says this is the process that we want to use for a very limited number of state employees for a very limited purpose. And they set that out. Chapter 70A.28 does not have any exception to 17A in there. And if you go through the exclusivity analysis that you would do, that we cited to, everything from Kerr and Papadakis, Janetsky, Ghost Player, which would be a more recent case, you go through and you decide, is there agency action? If there is agency action and it's related to the legislative mandate directed to that agency, it's exclusive.
What do you make of the citation to the Worthington case? You heard Mr. Duff talk about that a little bit, and as I know you know, that is in the Walsh case, and that did involve 8015.
Actually, it did not, and that's really a key distinction, Judge. If you look at Worthington, what happened in Worthington was that when Worthington was put on paid administrative leave before there was anything done under 8015, she filed for injunctive relief under the whistleblower statute. Didn't implicate 8015 at all. In fact, if you look at footnote 2 in that case, 8015 couldn't have been involved because there hadn't been any disciplinary action that affected the loss of pay. There would have been impossible for 8015 to be involved at that point. Like many things, timing is everything. And if you look at footnote 2 in Worthington, the court even notes that the issue may have become moot because later on they did institute the 8015 process, which ultimately resulted after going through that entire process with her termination. So that's a big distinction there. It is not an 8015 case. Worthington stands for nothing more than the fact that if you have a remedy available by statute for injunctive relief, that trumps the court's equitable powers to issue equitable relief. That's all that was decided in that case, and that was the issue in the case, and it really doesn't have anything to do with 8015. Certainly doesn't have anything to do with exclusivity, which is what we're focused on here.
Given kind of the college try, but I joined Justice Apple's opinion, and if we're not persuaded by that, and we also come to the conclusion that the complaint against himself was also a complaint against other people, although I know in the modern fashion he says, I accept full responsibility. Do you have any other reasons why at least the whistleblowing claim doesn't need to be sent back?
Okay. Well, I want to reemphasize exclusivity and the 40-plus year history of the exclusivity analysis, which directly applies here. And in addition to...
But it would apply... I mean, that could have been argued in Walsh, too, and I think it was to some extent.
Well, it really... I don't think it was argued in Walsh. It certainly wasn't addressed by the court. And one thing I'll point out is the legislature knows how to do this. If you look at Iowa Code 216.16, under the Iowa Civil Rights Act, the legislature expressly states, notwithstanding 17A, state agencies have to file this complaint first with the Civil Rights Commission before they can proceed. The legislature knows how to put that language in there. They've done that in the Civil Rights Act. They've done that in the Iowa Tort Claims Act. It would have been an easy thing to do when 70A28 was adopted. It's an easy thing to do now if the legislature were to deem that that was something that they wanted to do. So
Walsh was wrongly decided, probably, because it doesn't have the express language.
Well, no, I don't. That's not the argument I'm making, Judge, because Walsh dealt with a different issue and dealt solely with that interplay between those two statutes. It didn't take up the exclusivity argument.
We addressed it, though, did we not? We cited language from the Administrative Procedures Act that you're citing.
You cited that language, but Walsh doesn't even make a determination that agency action was involved. And
no one contested that, actually, in Walsh, I don't believe.
What I think, and Walsh was really, that was the argument was really an exhaustion argument there, which is what the court addressed more head on, as opposed to the exclusivity argument. And I think that those two cases can easily be reconciled. Again, Justice Apple, based on legislative history, legislative intent, and the fact that 8015 preceded even the civil cause of action under 7828. And if you look at the Kerr case, they say even if the statute came afterwards, you still have to put that notwithstanding 17A language in there. And as I pointed out,
following up on Justice Mansfield's question, is there an alternative argument under the 70A28 claim? I thought you were making an argument about the report wasn't made to the appropriate person within the meaning of the statute. Could you elaborate on that a little bit?
Yeah, yes, I can, Your Honor. We've already discussed the fact that the complaint against himself was sent to either the DCI director or the commissioner or both. The other complaints that he made was made to a personnel officer at the Department of Administrative Services, who under any analysis relating to public official would not qualify. So none of those complaints were made to the appropriate body, and that's the Hageman case, which we cite in there. There's also an issue about if you're performing your duties, if part of your duties is doing what gives rise to the claim, then that also is something that isn't covered under the whistleblower statute. We've argued that as well. I think that we focused on, and I've spent a lot of time on the 70A28 issue, which is, I think, very distinguishable from the Walsh case. Talked about other aspects of intentional infliction.
Can you address the administrative exhaustion argument under the Iowa Civil Rights Act? And as I understand it, Mr. Hedlund was not terminated, but resigned, but then didn't indicate that with the ICRC.
Yeah, that's a very significant exhaustion issue that we've raised. He has two opportunities in the complaint form for the Civil Rights Commission to indicate whether he was forced to quit or retire. He did not do that any time. He said he was terminated. He clearly was not terminated. I think even Hedlund 1 noted that.
When you're forced to quit or retire, are you terminated?
That could give rise to a constructive discharge claim, which
when you're forced to resign, is that a termination?
If you're forced to, that would be if your conditions were so intolerable that you felt you were forced to resign. That's a classic constructive discharge.
So if you're forced to resign, I mean, he didn't check them. I mean, we know the boxes. We know the situation, I guess. But he did indicate he was terminated. And isn't that broad term of termination sufficient to include within it a situation where you don't have a realistic choice but to resign?
McElroy would indicate not, just because it isn't reasonably related to that other claim. There hasn't been any claim of being forced to retire or quit in the pleadings. There hasn't been any hasn't been checked in the boxes in the framework for the civil rights complaint, hasn't been addressed in the narrative in the civil rights complaint, and being constructively discharged, forced to quit, retire under McElroy wouldn't be reasonably related to a straight up I was terminated claim, and that's our argument on that. I see I'm about, in fact I am out of time. Thank you very much. We would ask that the district court's nearly 40-page opinion addressing this matter be affirmed in its entirety. He followed this court's precedent. The district court did right down the line and should be affirmed.
Mr. Peterzalek, thank you. Mr. Duff, you may present your rebuttal argument.
First, with respect to the tortious infliction of emotional distress, Mr. Hedlund did go to the doctor. He did take medications. It wasn't just that he couldn't sleep. Is that
enough, though? I'm sorry. Is that sufficient to establish severe emotional distress?
Oh, I think it is. I think if, along with the other physical symptoms he had and the fact that he went to a doctor and took antidepressant, anti-anxiety medication for an extended period of time, I think that does show severe emotional distress. Mr. Peterzalek pointed out that he was on leave when they went to his house. Well, he was on leave for stress, and when the officers went to his house, even they questioned why they were doing it that way, and it seemed like a bad idea to them at the time. There was, in fact, no written policy about how officers would be taken out of service. However, there is an affidavit from John Quinn, who's the former director of the DCI.
You know, I read those affidavits. I mean, and the point they made was that it was kind of a bad exercise of judgment, that this was not the way to do it. You were creating a risky situation. But not so much, the affidavits didn't say this is a way to, if you wanted to inflict emotional distress on someone, this was the way to do it. They didn't make your point about it. They just said it was sort of poor judgment. Isn't that relevant?
Well, I think former Director Quinn's affidavit does say that that was not the way it was done. That normally that they have the officer come in, and that I believe his affidavit said the only conceivable reason that they would do it that way would be to try to provoke a reaction from Agent Hedlund.
Since we're talking about affidavits, because those are persuasive when you have affidavits in your report or in your brief that's from some of the law enforcement agents. There was one comment that in your brief on page 34 that Niles believed the entire investigation was nothing more than a witch hunt. And so then that, of course, got me to looking at Niles' deposition, and he never said that. I believe that question was posed of him by the attorney deposing him. The question was, all right, did you think their questions were professional? And the answer, merely an opinion, but I would say, yeah, I suppose. Question, what led you then to believe at some point that they were conducting a witch hunt?
Well, and I believe, Your Honor, when he made that comment, he was also, before he was deposed, he was interviewed by the PSB, and his interview of the PSB, of course, was transcribed, and that's where he makes the statement that it seemed like a witch hunt.
So he's the one that said that?
Yes.
And that's in the PSB
it was
statement?
True. Yes, it was true for Niles.
And there were several affidavits as referred to by Justice Mansfield, and can you comment on that as well? Didn't it seem that they were more or less saying bad policy, but would you agree there was no policy saying what was done was contrary to policy?
Well, there was no written policy. There was a sort of, this is how we always do it, which is if we think someone's a danger to themselves or others, we ask them to come into we don't tell them why they're coming in, but we have them come into the station where it's a secure environment, and then we get their gun and their badge and their car, et cetera, and that is the safest way to do it, not only for the affected officer, but also for the people that are actually taking them out of service. So why they departed from that why they would depart from that and decide to go to his home at 6 o'clock at night, I think does rise to the level of outrageous behavior, particularly given what they were asserting. Now, I agree with Mr. Peterzalek that at no time was Larry mentally unstable, but that was what their assertion was, and if that is what they truly believed, then that, I think, does rise to the level of outrageousness. Before I have to sit down, I want to address Justice McDonald's comment about the 70A complaints that were made. There was the email that was sent to Commissioner Lunnan, he's clearly a public official. There were complaints made to PSB about Paulson, and there was a complaint made to PSB about Myers. PSB is part of the DCI or part of the Department of Public Safety.
Here's my question about that. Maybe that's just the way the statute's worded, but statute says if you complain to a public official or law enforcement, then that's covered by the whistleblowing statute. Now, what happens if you work for law enforcement, as Officer Hedlund did, then, automatically, if you're complaining internally, you're going to be complaining to law enforcement. Is that the way the whistleblower statute's intended to work?
Well, I think certainly if he made a complaint to his supervisor, probably not. But when you go to basically police internal affairs, the police of the police, I think that is covered. I think that is the law enforcement for the police. The other thing I would say about this issue about whether it's a complaint against himself, the DPS, when they investigated it, actually filed complaints against the trooper who actually didn't pull the governor over, and the trooper who was driving. And the complaints were filed, according to DPS, by Hedlund. So when those two troopers were investigated, they believed it was Hedlund that was complaining about their conduct. So clearly that is what DPS considered when they were making that determination. The issue of whether he was terminated he was terminated. There's just no question. He was terminated in July of 2013.
Why didn't you check the box that said forced? I mean, if I understand the facts right, it was his last day and before the administrative, and he sends in a resignation. No doubt. I mean, I take it that had he not done that, he would end up being fired. But wouldn't it have been at least more accurate to check the box, forced to retire?
Maybe, but I think the point, Your Honor, is that he was put in a position where he had to take retirement, because if the termination was allowed to go forward, he's going to lose $100,000 of sick leave. And I think the more important point here is that he would not have retired but for the conduct of the defendants. He had no intention of leaving the DCI. He loved his job. He was going to work there until his mandatory retirement age. So the defendant can't put him in a position where he is forced to retire and then argue about administrative exhaustion. Before I sit down, I do want to make at least a brief run at my argument about why this court should consider not using McDonnell Douglas in summary judgment cases that are brought under the Iowa Civil Rights Act. This question has been called before in the case of Smith versus Porter. Footnote 1, Justice Strite actually said, neither party challenges the validity or the viability of McDonnell Douglas after Desert Palace, so we continue to apply it to this case. And that's essentially what has happened over the years, is no one's challenged it other than today. Our challenge to the use of McDonnell Douglas is really twofold: that it contravenes the motion for the summary judgment rule and the Iowa Civil Rights Act mandate that the statute be construed in such a way broadly to effectuate its purposes. We also think that the application of McDonnell Douglas creates needless confusion among trial judges and trial lawyers by superimposing case law, federal case law, and federal statutory law onto the Iowa Civil Rights Act. With regard to the...
You may sum up, Counsel.
Okay. My time kept going up, so I thought maybe I had more time. Thank you, Your Honor. So we would ask, Your Honors, that this case that the judgment of the district court be reversed and the case remanded to the district court for further proceedings. Thank you very much.
Mr. Duff, thank you as well. Mr. Peterzalek, thank you again. Case of Hedlund versus Iowa. State of Iowa is now then submitted, and will sit on the bench in recess to allow the exchange and the students to leave who need to leave before we take up the next case.